Yes.
Good evening and welcome everyone to this session of the AOR lecture series for the AOR aspirants taking the exam in June 2025. Our guest speaker for today is Mr. Sunil Fernandes, senior advocate designated by the Supreme Court of India with a legal practice spanning over 2 decades across constitutional, civil, criminal, and commercial law matters. Mr. Fernandes was an advocate on record for over 15 years before his designation and has held key positions, including Additional Advocate General for the states of Madhya Pradesh and Punjab, and was also the standing counsel for the then state of Jammu and Kashmir for over 5 years in 2 different tenures. Born and brought up in Mumbai, or Bombay as Sir prefers, Mr. Fernandes is an alumnus of the Campus Law Center, University of Delhi, and Hindu College, where he also earned a master's degree in political science. Over the years, he has represented a wide spectrum of clients, including state governments and constitutional authorities, to public sector undertakings and national political parties. He also served as standing counsel for BACS Rajdhani, representing their interests before various legal forums in Delhi. Mr. Fernandes has appeared in some of India's most landmark constitutional bench cases, including Navtej Singh Johar versus Union of India, decriminalizing Section 377 IPC, Joseph Shine versus Union of India, striking down Section 497 IPC, and Indian Young Lawyers Association versus State of Kerala, the Sabrimala temple entry case. Sir regularly appears before various forums, including the Supreme Court, various high courts, NCLT, and NCLAT. With more than 340 reported judgments adding feathers to his cap, Mr. Fernandes remains a highly respected voice in India's legal discourse. Beyond litigation, Sir is an insightful legal thinker and a frequent contributor to public debates on law, governance, and social justice. His insights today on Shayara Bano versus Union of India, Swiss Ribbons Private Limited, Committee of Creditors of SR Steel India Limited, Union of India versus Shriharan and Mukesh versus State, spread over 3 varied topics and 5 cases in core areas is truly valuable opportunity for all the AOR aspirants. Before I hand over the floor to Sir, on a personal note, this introduction is especially meaningful to me. Mr. Fernandes has been a mentor, guide, a voice of reason, and a constant source of strength in my professional journey for the last 15 years. Having learned the ropes of the Supreme Court practice under his aegis, right out of college, to his continued support in all my milestones, including becoming an advocate on record myself, has been a privilege through and through. His belief in me, his generosity in sharing his wisdom, and the integrity with which he conducts himself, both inside and outside the courtroom, have been instrumental in shaping the lawyer I am today. And while I will always be deeply indebted to him and continue to look up to him for guidance and support, I'm so glad that you all also get to learn and grow with this lecture. I can speak for hours when it comes to you, sir, having been a long-standing junior from your chamber. But considering the aspirants are here to listen to you and not me, I will show some self-restraint. I would request the participants who have joined us live to kindly ask any questions that you might have in the chat box on YouTube, and we will ask, sir, those at the end of the lecture. Over to you, sir.
Thank you, Asta. Thanks a lot. You've made me sound much, much better than what I actually am. And thanks for the generous praise and for the generous introduction. Um, and to everyone who's there online and watching this or would watch it later on, the first thing that I would like to share about this examination is, and before I get into the various case laws, is that please appreciate that this is probably the most impactful and most practical oriented examination in your career. I'm sure all of you all by now would have completed 5 years of practice. And before that, your schooling, your college, whether it may be a 12 plus 5 or a 3 plus 3. And you must have attended so many exams and I'm sure with distinction. But most of the exam, as is the nature of the exam itself, would be theoretical in nature. They would essentially test your theoretical knowledge. Even the papers that we give during our undergraduate courses in law college are essentially a test as to how much have you mastered the theory. But this is the only exam in my lifetime that I have given and which I would heartily commend. The only exam that has a direct practical application. So don't take it as if it's another examination which you would give in a long line of exams that you've given up till now in your life. View it as a professional assignment. For example, if a client gets in touch with you or an advocate on record gets in touch with you or an advocate gets in touch with you and asks you to draft an SLP, you don't take it as an academic exercise. You take it as a professional endeavor, because that has a direct connection to your growth as an advocate. This exam is exactly that way, because whatever you shall study in this examination and whatever you shall write in this examination, be it on the leading cases or on constitution or on Supreme Court practice and procedure, would have a direct nexus, direct impact on the lawyer or the advocate on record or the Supreme Court practice that you would do in the future. So please imbibe everything, not just as with a perspective to clear the examination, but please imbibe everything that these papers offer you, so that you become a better lawyer and you become a more well-endowed lawyer, and you are able to practice better. And once you are able to gain these skill set, with this examination, with this intensive study of this examination, not only will you be able to practice better, you will be able to provide better service to your client and get better name, fame, and of course, the consequent financial benefits. So having given a preface about this examination and its importance, and I hope you all look it in the right perspective, there are 5 topics today that we have to discuss, out of which 2 topics are squarely in the criminal domain. They are essentially about death penalties. 2 topics are on the realm of commercial law, that is insolvency and bankruptcy code. And there's one on Muslim personal law, or personal laws as we call it. Now, my endeavor during this talk is not to give you all the theoretical basis of it, because I'm sure almost every one of you all would be capable enough to read a judgment and understand which paras are the facts, which paras are the discussion, which paras are the ratio, and which paras are the conclusion. So my endeavor is not on that, because that is something that you guys can very well do. My endeavor in this speech, this talk, is going to be to discuss the basis, the fundamental basis in which these judgments are passed. Clarify the theoretical principles, its practical applications, so that when you all go back and start reading these judgments, the speed and the clarity is much better and faster. So that is what my endeavor is, to give you all a background, a basis, clarify a few concepts, so that when you all get back to the judgment, things which otherwise, you would hit a roadblock. You would read a judgment, there are certain complexities in some of the judgments, and then that takes time. Then you get stuck. Then you try to comprehend certain concepts which take time, and within that sees that it ensures that you don't complete your judgments within the requisite time. So that is something that we would like to take care of. And this is the entire the effort of this lecture. So if we can just straight away come to the the case laws that we have. On criminal law, that is on death sentence, we have 2 case laws to discuss. Union of India versus V. Shriharan and Mukesh versus State. Also, the first case, V. Shriharan, was popularly known as the Rajiv Gandhi assassination case, and the second one is the Nirbhaya case. So if those of you all have access to an SCC with you, please open it. If you all don't have an access, no worries, I'll take care of the rest. I'll just you need not be quite anxious about noting down everything I say. If at all anything needs to be noted down, I'll let you all know. Just basically have just sit back, relax, and just have an overview of the judgment first. So 2016-7 SCC page 1. This is the first judgment, Union of India versus V. Shriharan. It's a constitutional bench judgment of 5 judges of the Honorable Supreme Court. And what is this that this judgment actually did? How did this judgment actually originate? Now, this judgment came about because you all must have read about it, or must have even had some idea about it, that there was our former Prime Minister Shri Rajiv Gandhi was assassinated by the LTTE in 1991 in Sri Perumbudur in the state of Tamil Nadu. And then the criminal trial went on. The people who were part of the criminal conspiracy were arrested. They were given death penalties, etc., etc. Now, the state of Tamil Nadu proposed to remit the sentences of some of the accused persons. And the matter reached the Supreme Court because there was a writ petitioner who challenged this process, saying that there is challenged the power and the authority of the state of Tamil Nadu to remit the sentences of those accused persons in the Rajiv Gandhi assassination case. And since the Supreme Court felt that this is a question of which requires interpretation of the Constitution, it referred this matter to a constitution bench, a bench of 5 honorable judges. So before that constitutional bench, there were 7 broad questions that the Honorable Supreme Court had framed. And one of the ways of trying to understand a judgment is, first and foremost, you should have a clear idea about the citation. So whenever you write about leading cases, the citation, that is the exact cause title, and its citation is something that it is preferable that you all remember, so that gives an accuracy as to what judgment are you all talking about. Secondly, you all should have an idea as to what was the strength of the honorable judges who were a part of that judgment, whether it is a 2-judge bench, 3-judge bench, or a 5-judge bench. The next thing that you all should note down or analyze is, was it a unanimous judgment, or were they dissenting judgments? Now, unfortunately, due to constraints of time, in these 5 judgments, I will be only talking of the majority judgment. I will not be talking of the minority view. That is something that you all can go through. And of course, it is expected that you also write a few paragraphs on the minority view also. But the judgment is what the majority says. And the correct way to approach is at least to pen down and to comprehend as to what the majority view is. So there were 7 questions that were formulated. And to those who want to note down, please note down para 8 of this judgment at page 51, where 7 issues or 7 questions the Honorable Supreme Court framed with regards to the instant matter. Now, which are those 7 questions? Let me just read it out for you all for the benefit of those who don't have an SCC. The first question was whether imprisonment for life means till the end of convict's life, with or without any scope of remission. That was the first question. Second question, whether a special category of sentence instead of a death for a term exceeding 14 years can be made by putting that category beyond the grant of remission. Then the third questions pertain to the powers under section 432 and 433 of the then CRPC, read with article 72 and 161 of the powers of the president and the governor respectively. The fourth question was with regards to primacy of section 432(7). That's not that big an issue, but I'll advert to that later on. Fifth question was whether 2 appropriate governments can act under 432. Sixth question was whether the power under 431 can be exercised suo motu, following the procedure prescribed under 432. And the 7th question was whether the expression consultation in 435 really means concurrence. Now, to understand all these rather elaborate and complex questions, firstly, you all should have conceptual clarity as to what are the powers under 72(161) on one hand, 432 and 433 CRPC on the other hand. So there are 3 concepts here. So you have a criminal trial, the accused gets convicted, matter reaches up to the Supreme Court. Now, which are the 3 powers that are there in our constitution and the statute which directly impacts the sentence of the accused persons? The first is the constitutional power, that is under Article 72, the President of India, and Article 161, the Governor of India, a governor of any state in India, has the power to what is known as grant pardon. So when they grant pardon, if supposing some person has been convicted by the trial court, conviction upheld by the High Court, conviction also upheld by the Supreme Court, the presidential pardon can mean that he can get, if it's a full pardon, not only his sentence goes, the rest of the sentence that he is supposed to undergo, even the conviction gets effaced. So it's a full pardon means no conviction. It is as if he was never convicted. Of course, the years that he spent behind the bars, that cannot be given back to him, but at least his record is wiped clean. So that is what is known as the power of pardon. And the power of pardon is found in our constitution at 2 places, Article 72 insofar as the exercise of that power by the Honorable President, His Excellency the President, and 161, His Excellency the Governor. These are the powers of pardon, the first head. The second head of powers, whereby the state can what is known as remit the sentence or commute the sentence. Now, many a times these two concepts are used interchangeably. Please understand there's a nuanced difference. Under Section 432, the state government can remit the sentence of any accused persons based on any application. So, for example, if a person has been convicted and he's been sentenced, say, for 10 years of imprisonment, and he has already, say, undergone 5 years, the state government, based on certain guidelines which are well entrenched, can say that under 432, I am remitting the rest of your sentence, meaning thereby he has to undergo only 5 years. And for the rest of the 5 years, he need not suffer incarceration. Now, this remission, this power for the state government is found under Section 432 of the CRPC. There is another remission which is found under the prison rules. That is not something which is covered under 432. That remission is that supposing if you have under the prison rules, for every good conduct, for every year of a good conduct, you get certain additional months added up. So, for example, if you have spent 1 year, and in terms of the prison rules, in terms of the jail manual, if your conduct has been exceptionally good, or it is conduct has been as per the desired standards, then say you get 3 months of remission. So even though you have spent 1 year, your total sentence would be counted as 1 year, 3 months with remission. So therefore, there are instances where somebody, say, applies for, say, bail in the Supreme Court, and he has been convicted for life. And very often, Supreme Court, this question you would have realized the honorable judges ask this question: what is the period that he has undergone, and tell us with remission and without remission. So therefore, we tell the judges that yes, with remission he has undergone 10 years, without remission he has undergone, say, 8 years. So that is the benefit that is given, so that it encourages good conduct. So you have remission, the power of the state government under 432, and another source of remission which is there under the prison rules. The third concept is commutation. Commuting a sentence is found under 433 of the CRPC. Now, how is commuting different from remission? In remission, you just take out the remainder of the sentence. In commuting, you alter the nature of sentence. For example, if someone has received a death penalty, by virtue of commuting, you can convert the death penalty into life imprisonment. Now, if someone has received life imprisonment, you can convert that into a specific period of time, and so on and so forth. So commutation is changing the nature of your actual conviction. Now, in this case, in V. Shriharan's case, one of the issue that cropped up was, and when we say that the so-and-so convict has been sentenced for life. Now, what does life mean? Because in our Hindi films, all throughout, life used to mean 14 years. So the idea was that if someone who's been convicted for life has spent 14 years inside the prison with or without remission, mostly with remission, then he's entitled to get an exit. He's entitled to be freed. So that was clarified, that 14 years is not what is a life sentence. Life sentence means life. So if somebody has been convicted for a life sentence, that means the sentence will continue to run for the rest of his remainder natural life. So if he's convicted at the age of 30 and he lives on till the age of 70, the conviction will extend from 30 to 70 for 40 years till he, say, passes away at the age of 70, for example. Now, this is subject to, as I said, powers of pardon. So he may not need to spend entire 40 years. He can receive presidential pardon, or his sentences can be remitted either by powers of remission under 432 CRPC or under the prison manual, under the jail manual, prison rules. And third point aspect is he can get the benefit if his sentence to life is converted into some lesser sentence under the power of commutation under Section 433 CRPC. So these were the one of the major things or the legal issues that was clarified in V. Shriharan is that sentence for life means for your rest of your remainder natural life. It does not mean for 14 years. Now, in an earlier judgment in Swami Shraddhanand's case, Swami Shraddhanand versus State of Karnataka 2008 judgment, the Supreme Court created a special category of cases, as they call it. Now, what is this special category? Special category of cases, supposing the trial court has sentenced a person, say for murder, he has sentenced the person for to death. And the death penalty has been upheld by the High Court because there has to be a compulsory reference to the High Court in a death penalty case. Matter comes up to the Supreme Court. Now, the Supreme Court feels that there is sufficient evidence on record to warrant a conviction. So they don't want to tamper with the finding of conviction. But at the same time, they feel that this has just fallen short of the rarest of rare case test that we have for death penalty. And they feel that sending this accused person to the gallows may not be the right course of action. Then they also would feel that sending him to imprisonment for the rest of his remainder life may also not be the right course of action, assuming he's a 25-year-old young man. And by the time this matter comes up to Supreme Court, as I gave that example, say maybe 30. So is the Supreme Court looking at putting somebody behind the bars for 40, 45 years? So therefore, a special category of cases was created. Special category of cases, Supreme Court came up with a via media. That is, instead of death penalty, Supreme Court awards a fixed tenure of sentence without remission. So Supreme Court says that, see, otherwise you would have gone to the gallows, you would have been hanged till death. So I am not sending you to be hanged till death. But I am also not going to let you out, say in 10 years or 12 years, because for him, if you take it as 14 years as a life imprisonment, so with remission, he would have to barely spend 10, 11 years. So what I will do is I will ensure that you spend at least 20 years or 22 years or 25 years inside bars without any remission. So this is actually a win-win situation where the convict is saved from the gallows, but at the same time, he doesn't get away cheaply. He pays the price for his crimes. And this is the way that Supreme Court has balanced out. Now that Swami Shraddhanand's principle also has been upheld by the Supreme Court in Shriharan's case, that yes, the special category cases are valid. Then the next point that the Honorable Supreme Court dealt with in Shriharan's case is now the question that now there are competing interests in the question as to who will exercise the power first. Now, because under 72, the president has the power to grant pardon. Under 161, the governor has the power to grant pardon. So the next question was, who among the two will get the primacy? So that has been answered by the Supreme Court to see that you please look at the nature of offenses. If the nature of offenses are such that they are federal in nature or pertain to crimes which are under central statutes, then in that case, the power of the president under 72 will get primacy over the corresponding powers of the governor under 161. So that was a theoretical question that they had to decide, and which was decided. Then another point that cropped up was when it also says that before the state government either remits a sentence under 432 or commutes a sentence under 433, there has to be a consultation with the central government under section 435. Now, the question before the Supreme Court in this constitutional bench judgment was, consultation means what? Is supposing state government wants to commute a sentence. It has to consult the central government. Central government gives a negative opinion. Is that negative opinion binding on the state? So therefore, it cannot mean a mere consultation. It's a higher thing. It means there has to be a concurrence. Or does the state have the power to reject the advice given by the central government and say that notwithstanding your advice to the contrary, which we respect, but we still want to proceed ahead? Now, the Supreme Court held in Shriharan's case that consultation means concurrence. So any opinion given by the central government on this issue would be binding on the state government. Then there were a couple of other issues that they were dealt with. I can just quickly yes, then another point was whether section 432, when it talks of remission, can the state government suo motu decide to remit a sentence of an accused person, or should the accused person move an application and only then the state government can act? So this is an important point because this is to ensure that if any state has to exercise a power of remission, there has to be a formal application before it. And the Supreme Court held in Shriharan's case that you have no suo motu powers. You can remit a sentence only when there's a formal application. So these are the broad concepts about it. When you delineate these several questions and read through it. So when you read through it, please read in the light of whatever I have told you all, so that probably it will become easier, faster, and better to comprehend the judgment. And lastly, for everyone's convenience, please note para 176 at page 137 of the SEC volume. This is where the Supreme Court has given a summary of its finding on each of the 7 questions. So it's just a trick of the trade which I would like to share. Whenever there is a complex judgment or very lengthy judgment, so first start from the end. So first go to para 176 at page 137. See what have been the answers to the questions given. So normally in a few paras the answers are given, and then go back to the first page and read the entire judgment in light of that answers given. So that what happens is, if you start reading a judgment and start analyzing the judgment, which say is 100 pages, 150 pages, by that time you end up into 100 or 150 pages, you may have lost track as to which direction the judgment is actually going. So if you know the conclusion first, if you have read the conclusion first, understood what is the final decision of the Supreme Court, then keeping that in your mind, go back to the first page and then start the journey towards analyzing a judgment. So just don't read it. So the difference between reading a book and reading a Supreme Court case is that you can read a book at leisure. But when you read a Supreme Court judgment, you have to analyze it. And what is the analysis? You'll have to find out as to how this judgment came about, what was the origin, what were the questions, and how the Supreme Court has dealt with each of those questions, what has been the reasoning process, and then the conclusion. So merely by knowing the conclusion is not good enough. So merely by saying in a given judgment, Supreme Court has upheld the conviction, that's it. That's the end result. But the antecedent part, that is, what was the basis on Supreme Court to arrive at that decision, that is very important. Because once you learn that, or once you comprehend that, then you can use it in your own cases when you become an advocate on record. So the conclusion is only the first part of it, but the more important part of it is the process to reach that conclusion. Imbibe that, so that when you get a judgment from the High Court and you have to draft an SLP, you can imbibe those principles that the Supreme Court has adopted, the Supreme Court has taken recourse to set aside, say, a conviction, which then you can do it, or conversely to uphold that conviction. So this takes case of Shriharan. The next case is Mukesh versus State of NCT of Delhi. This is also a classic case as to what are the contours of a death penalty, as to when a death penalty can be upheld. And this is known as the Nirbhaya case. Those who've been from Delhi or have lived here for a certain part of time would know the gruesome rape and murder of Nirbhaya in 2012. And the genesis of this is unfortunately a movie that she went to watch along with a friend at a movie theater in the southern part of Delhi, Life of Pi. Although this is trivia, this is not to be quoted in the examination. Life of Trivia, of course, it's another Indian connection. It's the lead actor in that, Suraj Sharma, an Indian actor, along with Tabbu and the late Irfan Khan. So she watched that movie, and after that movie got over, late in the evening, she boarded the bus. And then I think everybody knows the gruesome acts that were committed on her. And that became a source of, and correctly so, a source of national outrage. So then the accused persons were apprehended, they were convicted, the trial court convicted them, awarded them death penalty, matter went up to the High Court, the conviction as well as the sentence was upheld, and then the matter reached up to the Supreme Court. So in Supreme Court, several defenses were raised by the defense lawyers. And this judgment is a journey for you all to understand as to what are the defenses that can be raised, and how the Supreme Court has dealt with those defenses, and then what constitutes a rare of a rarest case to uphold the sentence of a death penalty. So there, if you all see, at para 47 of this citation, of that is 2017 6 SCC, page number 1. And also, this is a distinction between us Supreme Court lawyers and the rest. When you give an SCC citation, please ensure that the brackets are at the correct place. You don't put the volume number under brackets. You put the year under brackets. So it's 2017 within brackets 6 SCC, 1. And SCC being in capital. So there, and if you come to page 47, para 47, at page 65. So from here, the various issues commences. From para 47 onwards. Para 47 at page 68. I'm so sorry, I stand corrected. Para 47, page 68. The first issue, the first defense that was raised was there was a delay in the registration of an FIR. That's the one of the first issues. The second issue that you will find at para 56 is non-mentioning of the assailants in the FIR. The third issue is recovery of the bus and CCTV footage. Fourth issue is the personal search. Fifth issue is the test identification parade. Sixth issue is the dying declaration. And then all of it is then it's a three-judge bench judgment. I'm sorry, I should have clarified that at the start. Is a three-judge bench judgment, and the judgment has been authored by Justice Deepak Mishra with Justice Bhanumati concurring. And then the summary of conclusions, and you all can note that at para 311, page 166. This is the summary of the conclusion for the entire exposition of that case law. And while you're reading it, I would urge, please, if this from the SCC volume, please also read para 159. That's actually quite soul shattering. It's quite gut wrenching, the ordeal that she had to undergo. Because even if there is any case where it leads to a violation of the body is gruesome. But in this case, it didn't stop at that. It went far in excess to a mere violation of a woman's body. There was a certain dastardly acts which it was shocking to even to read it, even in an SCC volume. And I wonder how that poor girl must have undergone that when it is so difficult to even to read it. And unfortunately, she passed away after battling for her life for a couple of weeks. So then the Supreme Court has relied essentially on the testimony of PW1, her friend who was also there in the bus and who witnessed this in the first-hand account. So he was the eyewitness. His testimony was held to be unimpeachable. The second legal aspect in this judgment, which is also very important for you all to read, is on the principle of dying declaration. That is covered under Section 32 of the Evidence Act. See, normally, the principle of dying declaration is an exception to the normal rule of evidence. And why I say an exception? Because in the normal rule of evidence, if there is a testimony or a statement by any of the witnesses against an accused person, unless the accused person has the right to cross-examine that person who has given that prosecution witness or that witness who has given that testimony, then that testimony is not considered as evidence, and that testimony is not taken into reckoning by the trial court to decide a sentence of conviction or an acquittal. The exception to this normal rule is, for example, if there is a living gentleman who has given a statement against the accused, that living gentleman has to be present in the witness box for the counsel of the accused person to cross-examine him. And only when the cross-examination stands concluded, only then that testimony of that witness, that is his examination in chief and his cross-examination, cumulatively is read as evidence. Now, Section 32, that is dying declaration of the Evidence Act, constitutes an exception to this standard norm, because as it's quite obvious, the person making the declaration is dead and hence no longer available to come in the witness box and get himself or herself cross-examined. That's why it's called a dying declaration. So dying declaration, and there was a very celebrated judgment of the Supreme Court in Paniben versus State of Gujarat, 1992. So Supreme Court has given certain parameters as to how are you able to judge a dying declaration. The underlying principle is someone who's going to meet his or her maker will not lie. So there is a great deal of authenticity and veracity attached to the last statement made before a person is about to die. Because this is a presumption of the Supreme Court that no matter how heinous a person might have been in his or her life, at the stage when that person knows, and dying declaration is only when the person is is dead, if supposing he makes a statement and he doesn't die, he survives, thankfully for that person, then that does not become a dying declaration. Dying declaration means necessarily mean that the person has passed away, is no longer there available to come to trial for a cross examination. So the legal principle of presumption is that any person who's on the deathbed about to meet his maker, as it's said, will not lie. So that is the presumption. And then it is tested on various parameters to see, is it cogent, is it relevant, and was the person in proper state of mind? Because maybe that, at the last stage, the person's mental state of mind is a very important factor to see whether is that person in a position to give a proper statement, because that statement has devastating consequences on the accused. He can be convicted solely on that statement without any other ocular, oral, or documentary evidence. So, in this case, the dying declaration was assailed by the accused persons of Nirbhaya. Nirbhaya's dying declaration, on several points it was assailed, and the dying declaration starts at para 148 onwards. So if you read para 148 at page 103, you will see the entire discussion of the Supreme Court as to what were the objections raised with regards to the dying declaration and how did the Supreme Court deal with it, and ultimately it decided to convict all the three accused persons, all the five accused persons, uphold that conviction. Then if you come to the third case, now before getting into those two IBC cases, since we are on the criminal law, the another aspect of that would be Shayara Bano's case, which is the triple talaq case, a very famous case known as the triple talaq case. And what is unique about this case is, and it was the bench, the composition of the bench. That's a glowing testament to the diversity, not only of the Supreme Court, but of our country as a whole. Now, who were the five honorable judges who comprised of that? The bench was headed by the then Chief Justice of India, Justice J.S. Keher, who was a Sikh, a practicing Sikh. There was a Christian on the bench, Justice Kurian Joseph. There was a Parsi on the bench, Justice Rohinton Fali Nariman. There was a Muslim on the bench, Justice Abdul Nazir. And there was a Hindu on the bench, Justice U. Lalit, who later on adorned the position of the Chief Justice of India. So there were five judges, all five of different faiths. And again, as I said, a remarkable testimony to our diversity, to our the social variety that we have in our country. That out of the five judges, only one was from the, although I have a dislike for using this term majority and minority, but that's how it's popularly understood. So only one of the five judges came from the majority community, and the rest four of them were from the minority community. And the five of them gave a very learned and a very erudite decision on this issue by 3:2. Three honorable judges, Justice Rohinton Nariman, Justice U. Lalit, and Justice Kurian Joseph, struck down the practice of triple talaq. And two other judges, the Chief Justice of India, J.S. Keher, and Justice Abdul Nazir, upheld that practice. This is also one of those rare cases in our constitutional history, from independence till now, where the Chief Justice of India in a constitutional bench is in a minority. Now, that's quite rare. I don't think there are, a single-digit instances since independence till now that the Chief Justice in a constitutional bench would be rendered in a minority. So here, Justice Keher's view, which along with Justice Nazir's view, was in a minority. The other three learned judges hold the majority view. And how did it proceed? Now, to understand the concept of triple talaq, surprisingly, this issue of triple talaq it did not directly emanate out in the Supreme Court. There was a case called Prakash versus Fulvanti, which is a citation is 2016 to SCC page 36, where the Supreme Court, a division bench of the Supreme Court, was dealing with a totally unrelated aspect. But during the hearing of that matter, the issue of the exploitation of women, especially under the triple talaq regime, came to light, and they passed a judicial order saying that this issue of triple talaq, the validity of it, should be treated as a PIL and be placed before the Honorable the Chief Justice to constitute a bench of appropriate strength and adjudicate this issue. Now, this can happen only in Supreme Court, and rightly so, because this sort of a procedural flexibility, even it would be seldom to find even in the High Court. Like, for example, if the High Court is hearing a commercial suit or a partition suit, and in that the High Court feels that, oh, there is this issue that has come up before me which raises important constitutional question about the right of women, about whether triple talaq is constitutionally valid or no. Uh, I seldom would a High Court judge refer it, or would have that sort of the flexibility in parts. The honorable judges in the Supreme Court have that, and that's why, as I said, this is not only the best court in the country, it is also quite the most powerful court in the country. So therefore they sent it to a 5-judge bench, the honorable the Chief Justice, and the 5-judge bench evaluated whether triple talaq, is it covered, is it constitutionally permissible or not permissible. So to understand that, there you if we see that judgment, the there are two leading judgments on that, on the majority view. Justice Kurian Joseph has penned a very short, a very appropriate and a very concise judgment, which runs into only 27 paras. And the more detailed exposition is by Justice Rohinton Nariman, which starts from page 54 at para 29. And that para 29, Justice Nariman gives the example of Prakash versus Fulvanti. Now, the issue there was about triple talaq as to how do you test it on the grounds whether is it constitutionally invalid or no. Triple talaq has the origin in a 1937 law of the Supreme Court, 1937 law known as the Muslim Dissolution of Marriages Act. It contained, it was a short act of only 6 articles, 6 sections, which contained everything, including marriage, dissolution, and divorce. And one of the grounds of dissolution of marriage or divorce was triple talaq. Now, after the Constitution came into force on 26 January 1950, Article 13 of our Constitution says that no law can be violative of the fundamental rights. And law also means any law that has been passed prior to the independence of the country. So all pre-independence laws also, after our Constitution has come into force, must pass the muster of fundamental rights. And if they violate your fundamental rights, then those laws cannot remain in existence. Now, the same issue was there. Please see at, just read out para 32 at page 55. So the question therefore posed before this court is finally in a very narrow compass. Triple talaq alone is the subject matter of challenge. Other forms of talaq are not. Next question that arises before this court is whether the 1937 Act can be said to recognize and enforce triple talaq as a rule to be of law to be followed by the courts in India. And if Narasu Appa Malli, which states that personal laws are outside the ambit of Article 13(1) of the Constitution, is correct. Now, this judgment, Narasu Appa Malli, is a 1951, it's a very vintage judgment, that said that when there are personal laws, this is laws affecting the marriage and personal aspects, marriage, divorce, child custody, maintenance, etc., which are personal in nature, Narasu Malli held that they are outside the ambit of Article 13. So therefore, they cannot be tested on the ground whether if they are violative of any fundamental right or no. They are in a separate category of itself, which of course later on the Supreme Court has refuted that, has set aside that sort of a reasoning. And the other aspect that should be one should realize about this is about the doctrine of, as I said, in if you permit me to read para 47 at page 65. It is therefore clear that all forms of talaq recognized and enforced by Muslim personal law are recognized and enforced by the 1937 Act. This would necessarily include triple talaq when it comes to Muslim personal law applicable to Sunnis in India. As you are aware, there are two major sects among Muslims, Sunnis and Shias. Triple talaq is applicable only to Sunnis and not to Shias. Therefore, it is very difficult to accept the argument on behalf of the Muslim Personal Board that Section 2 of the Act does not recognize or enforce triple talaq. It is clearly and obviously does both. And this section makes triple talaq the rule of decision where the parties are Muslims. As we have concluded, the 1937 Act is a law made by the legislature before the Constitution came into force. It would squarely fall within the expression, inverted commas, laws in force in Article 13(3)(b) and would be hit by 13(1) if it is found to be inconsistent with any provisions of Part 3 of the Constitution to the extent of such inconsistency. So therefore, when there is a law that is being sought to be challenged, if you are for the petitioners who are assailing a law, you all can say that this law is violative of Part 3. If you are for the respondent trying to defend the law, then you can say that this law does not offend any of the provisions. In fact, the respondents in that case, the Muslim personal law, went a step ahead. As I said, they took recourse to the judgment in Narasa Appa Mallu to claim that personal laws are outside the ambit of Part 3 of the Constitution. So any law that deals with the personal laws of, in this case, for example, the Muslims, cannot be tested on the touchstone whether it is violative of Part 3, that is fundamental rights. That argument was repelled and rejected by the Supreme Court, saying that, sorry, that can't happen. All laws before independence have to be tested by virtue of Article 13 under whether are they valid, constitutionally valid under Part 3, that is fundamental rights. Then there's another judgment that has been cited by Justice Nariman, that is the Sirur Mutt case. This is citation of that would be AIR 1954 Supreme Court 282. Now, Sirur Mutt's case also would be important not only here but also in your practice, because this gives us a very celebrated doctrine of ERP, that is essential religious practices. Now, our constitution, say Article 25, gives you freedom of practicing your own faith and religion. But it also says it is subject to certain restrictions. Now, the state brings about a law which constitutes a restriction on your practice, on your ability to practice your faith. Now, to what extent is that restriction valid? And to what extent is it constitutionally impermissible and hence invalid? The test to determine that is the ERP test, that is the Essential Religious Practice Test. That is, the practice that is sought to be regulated or stopped or outlawed by the state by bringing about a law. Is that the essential facet or essential aspect of the religion? If it is, then the state cannot make any laws to that effect. Just to give an example, we had this famous hijab case, which is there was a split decision by the Honorable Supreme Court from the state of Karnataka, where Justice Hemant Gupta upheld the hijab law, and Justice Dhulia, if I'm not mistaken, quashed it. Now, the reasoning that the hijab ban that was sought to be imposed in the state of Karnataka was on the ground that wearing a hijab does not constitute an ERP, that is an essential religious practice, meaning thereby, even if you don't wear a hijab, you can still be a Muslim. So therefore, if it does not constitute ERP, the state can make laws or rules or regulations. So that is the argument that is invariably put forward. And when the court has to, it's a very complex question because there are no easy answers here. And these are very difficult constitutional questions that which won't make any party happy. At the end of the day, some or the other party will always have a grievance to it. But this is the formula that the Supreme Court has evolved right from Sirur Mutt's case in 1954, that when you have to test the interplay between your religion and the right of the state to regulate the religion, you take recourse to what is known as an ERP, the essential religious practice. So if it meets that threshold, if this practice is essential to your religion, the state cannot interfere, cannot bring about any rule, law, or regulation. But if it is an ERP, if it's not an ERP, only then can the state interfere. So this is what, and then of course Justice Nariman's judgment are pretty comprehensive. They deal with various other aspects. And I also would like to share some experience that if at all, at times, if you all find the judgment a bit heavy, and if you all find that there are too many case laws that are cited or too many judgments that are quoted, and there is, if I can take the liberty of making a fair criticism, our judgments tend to be a bit on the heavier side. So I think we could, because a lot of sections are accepted, lot of provisions are accepted, lot of case laws are quoted, which tends to burden the judgment, and you then have to distill actually the ratio that the judgment is trying to come at. So therefore, even if so, if you feel that the judgment is a bit on the heavier side, and it could have been shorter, then don't be embarrassed about it. You're not the only one. Most of us feel the same way. And so, but as lawyers, we don't pen the judgments. We read them, we analyze them, and we argue them. So, and as aspirants sitting in the examination, you all also will have to do the same. You'll have to read it, analyze it, try to probably evade the verbosity part of it, and come to the actual ratio part of it. So, if the same point has been buttressed by citing several judgments, try to skip over it and come straight away to the ratio as to on what basis is the decision making done. As I said, knowing what the ultimate decision of the Supreme Court is important, but even more so important is the process that the Supreme Court has arrived at, has taken recourse to arrive at that decision, because that process is what is known as the ratio, is the discussion. So this is as far as Shayara Bano goes. They struck down the practice of triple talaq on the ground that it is invalid. And there's also one more para that you all should read, para 103, page 99. Now, there was a judgment of the Supreme Court itself in Shamim Ara's case. This is way back in 1985, 1 SCC 641. Shamim Ara versus State of UP, 1985, 1 SCC 641 at para 103. This Supreme Court has taken a great deal of inspiration from that judgment to come to the conclusion that triple talaq is unconstitutional. So that concludes the constitutional judgments and the criminal judgments. Now we come to matters of money, the commercial laws. And the Insolvency and Bankruptcy Code is the flagship economic reform of this government. It has created an entirely new legal ecosystem in which commercial litigation is being pursued and prosecuted in this country. And therefore, that judgment is quite important. And two of those celebrated judgments pertaining to the Insolvency and Bankruptcy Code is what we shall discuss today in the last part of my discussion. Whosoever is awake, thank you. I've spent an hour speaking. And if you all are still awake and haven't dozed off, you have my eternal gratitude for that. And with regards to now the Insolvency and Bankruptcy Code, now this is a pretty nascent judgment. It came about only, it was notified only in May of 2016, and actually it came into full swing in 2017. Now, what is insolvency and bankruptcy? Now, earlier there were several statutes which dealt with these problems. The IBC is, a reason why it's a code is that it seeks to codify everything, and I will point out the major areas of both those judgments. But before that, my endeavor again is to give some clarity on the underlying concepts. You'll be come across various terms such as resolution applicant, resolution professional, committee of creditors, CIRP, that is corporate insolvency resolution process, section 12 capital A, section 29 capital A, the commercial wisdom of the COC, and so on and so forth. So there are several such jargon that comes about, which can be quite daunting, because it has become an heavily litigated, and there's an immense fountainhead of jurisprudence that has come about from the Supreme Court and also from the National Company Law Appellate Tribunal on various issues headed by Justice Bhushan, Ashok Bhushan. So IBC, what it does is it creates a platform whereby you can approach a body known as the National Company Law Tribunal to enforce what is known as the insolvency of your debtors. Now, if to those you would recollect that the Companies Act was a new Companies Act was brought into force in the year 2013. And that new Companies Act, that is, which is still in vogue, the 2013 version, contemplated creation of a tribunal known as the National Company Law Tribunal, NCLT. And it also contemplated an appellate tribunal known as the National Company Law Appellate Tribunal. And any appeal from the NCLT was, the provision was made that an appeal should lie under Section 61 to the NCLAT, that is the National Company Law Appellate Tribunal. And any appeal from the order of the NCLAT would directly lie to the Supreme Court under Section 62. So before 2013, the jurisdiction to handle such cases was with the high courts, the respective jurisdictional high courts. After this 2013 Companies Act came into the picture, all companies related cases was contemplated to be done by this specialized tribunal. And say Article 323A and 323B of our Constitution gives the power to the central government to create tribunals on various issues and topics. And it is on basis of that constitutional power that we've had the Central Administrative Tribunal, the CAT, because before the CAT came about in the late 80s, all these matters pertaining to service jurisprudence were handled by the High Court. Then we also had the Debt Recovery Tribunal in the 90s. We've had the National Green Tribunal, NGT. We've had the Debt Recovery Tribunal also having jurisdiction under SARFAESI. And now increasingly we have seen an era whereby more and more tribunals are being created under various specific statutes. And gradually the jurisdiction of the High Court is being, to quote for want of a better phrase, is being salami sliced. So every law that is passed by the parliament which contemplates creation of a specialized tribunal would necessarily oust the jurisdiction of the High Court, unless and of course it's 226. But under 226 also, when you have an alternative statutory remedy, it's very difficult to approach the High Court under 226. But be that as it may, this is the situation as it exists, and most of the tribunals have been created so that to ease the burden ostensibly of the High Court and to have a specialized forum for such adjudication. So we had the companies, just to come back to the topic at hand, Companies Act 2013, that contemplated creation of the National Company Law Tribunal and National Company Law Appellate Tribunal. All company related cases were to go to this tribunal from the High Court. That was the original legislative intendment. Then we have the IBC that was created, that was passed by the Parliament in 2016, came into force towards the end of 2016, fag end of the year. And it said that all insolvency related cases should go to the NCLT. So the jurisdiction of NCLT exponentially increased, because the practical aspect today is that after every one case pertaining to Companies Act before the NCLTs, there are 10 cases pertaining to insolvencies. And now what is insolvency? Now, insolvency is something that a financial creditor or an operational creditor can file a case in the NCLT, the various jurisdictional NCLT, there are around 11, 12 benches all over the country, against a debtor. Now, who is a financial creditor? Now, the first and foremost term that you all should recollect or remember is a financial creditor under Section 7 of the code, that is the IBC, and an operational creditor under Section 9 of the IBC. These are the only two categories of creditors who have the right to approach the NCLT for this specific instance. Now, who is a financial creditor? A financial creditor is that person, for example, who against whom the debtor owes a financial debt. In practical terms, although Section 5(8) of the IBC defines what debt is, in practical terms, banks and financial institutions are the ones who would normally give financial debt to debtors. And when they are not able to pay the money, then a Section 7 petition is filed, or a Section 7 application as it's called, in which it is averred that, that this much loan was granted to the debtor who is now known as the corporate debtor. The correct terminology used in the IBC is a CD, a company who's a debtor of a financial creditor. The financial creditor will file an application under Section 7. Its nomenclature is application, but it's as good as a substantive petition. And the Section 7 applicant will say to the NCLT that, see, I had disbursed, say, 100 crores of a loan to this corporate debtor, and they had to repay this amount by, say, a certain period of time. They have failed to do so. Hence, I am moving this petition. And the end result of this petition is to declare that it is an insolvent company and take consequential steps. Now, what do you mean by an insolvent company? So, when under Section 7, a bank or a financial institution approaches, under Section 9, an operational creditor approaches. Now, who's an operational creditor? Again, clear that concept. Operational creditor is a creditor who has supplied goods or services to a corporate debtor. So, for example, it's a steel plant and you have supplied, say, 100 tons of coal, and the debtor hasn't paid the consideration or hasn't paid the full consideration for it. Then you become an operational creditor under Section 9, and you can file a Section 9 petition or Section 9 application before the NCLT. So the first step is that there has to be a debt. It can be a financial debt or it can be an operational debt. If it's a financial debt, then the financial creditor, Section 7 application is filed. If it's an operational debt, then a Section 9 applicant files what is known as a Section 9 application. So that's your first step. Then notices are issued. The corporate debtor comes. He has to defend himself. Now, whether that defense is accepted, not accepted, that's for the NCLT to decide. But if, and this is supposed to be a summary procedure, this is not like a civil suit where there'll be evidence-led or testimonies and etc. etc. It's just a summary procedure based on the respective documents. Now, if the corporate debtor is not able to prove his case, then the NCLT passes what is known as an admission order under Section 12 of the IBC. Now, what does an admission order do? And the reason why today IBC is so much into the limelight is that every promoter or every owner of a corporate debtor is mortally and morbidly afraid of an admission order. Because when an admission order is passed, at that very time itself, and a person known as a resolution professional, RP, this is again a very frequently used term that you must have come across, is appointed, and the resolution professional immediately takes charge of the affairs of the company, and the promoters or the owners of the company are ousted on day one. So this is the major change in the process before what was followed for the last 20, 30 years, that is before the DRT or before the IFER or BIFER, etc. The process there was that in, say, for example, in DRT, the banks would file what is known as an OA, an original application. And even if that original application is ultimately allowed after a very rigorous and a long-winded process, the promoters or the owners of that corporate debtor would still not be out of the control of it. They would still retain court control over it. Whereas here in NCLT, although the time limit is pretty stiff, 21 days, 14 days, but never happens. But yes, in a few months, this does get adjudicated. So within a few months, if it's adjudicated and an admission order is passed, the promoters are out. The entire running of the company is in the hands of what is of an entity known as the resolution professional. So we have discussed what a financial creditor is. We have discussed operational creditor, financial debt, operational debt. Then we have then a Section 12 order, which is an admission order. And based on the admission order, a resolution professional takes charge of the affairs of the company. The next stage is the resolution professional is supposed to conduct what is known as a corporate insolvency resolution process. CIRP. Now, what is that? What is, again, it's a slightly complex sounding term, but in simple terms, the RP takes charge of the affairs of the company, of the entire control of the company, and then calls for claims from the entire wide world. So everybody who's a financial creditor, operational creditor, or has some other credit claim can file claims before the RP. That is step number one. Then step number two is the RP collates those claims, decides as to, a prima facie examination he conducts to see whether are the claims genuine, valid, etc., etc. And then once the claims are decided, the claims are fully with him and he has gone through all the claims, he publishes a list of all the creditors. Then the next step in this is the creation of a body known as the COC, that is the Committee of Creditors, another acronym which you would read almost every day in the newspapers, definitely in the business newspapers, is the COC, the Committee of Creditors. The resolution professional is supposed to, as the head of the COC, is also to formulate a COC based on the claims received. Now, who constitute the COC? The COC is essentially, at least the vote, for the important part, the voting member parts, are those who are the financial creditors. So all financial creditors are a part of the committee of creditors. Then the next step is that the committee of creditors headed by the resolution professional calls for what is known as resolution plans. Now, a resolution plan is a plan given by an entity known as a resolution applicant, saying that, say the total dues of this company, say, is, again, just to quote that figure, maybe say 1000 crores. Now, I am giving you a plan, say, of 750 crores, in which I propose to pay everybody in this format, in this formula, and then that person is known as a PRA, a prospective resolution applicant. So similarly, there are several PRAs. Somebody may bid 700, somebody may bid 750, and then the COC evaluates, and the COC decides which of the PRAs has to be made as the successful entity known as the SRA. Supposing there are 10 PRAs and the COC selects one of them, then that selected entity from a PRA becomes the SRA, and that person is given the control and entire charge of the affairs of the company. And then that person is able to run that company in a smooth manner, in a manner which was far better than what the corporate debtor did. So this is the entire concept of insolvency, that these assets are at the end of the day national assets. And if the promoter is, or the owners of that company are not running that company in a manner that is giving the best benefit to the company, its shareholders, its employees, and to the economy at large, then, and most importantly, is not servicing its debts to the financial creditors and the operational creditors, then such people don't have the right to be in charge of the affairs of the company. Then they should be ousted. And they should be ousted, and someone else should come in, and that person should be given access to all the assets, and that person should run the company. So that's why this is something which, as I said, has put the fear of God in most of the promoters, because they know from day one the company will be taken away from your control if you don't satisfy or settle the debts. Now, having said this, the two judgments, Swiss Ribbons and COC versus Satish Kumar Gupta, both of them authored by Justice Rohinton Nariman. Now, first judgment is Swiss Ribbons. It was a two-judge bench judgment, Justice Rohinton Nariman and Justice Naveen Sinha. The citation is 2019 4 SCC, page 17, 17. And which are the various issues that that judgment dealt with? Firstly, it dealt with the constitutional validity of the IBC. And in the light of what I have told you all, please read it. It will become much clearer. Hopefully, you'll be able to understand that why the Supreme Court ultimately said that it is constitutionally valid. Then the distinction between a financial creditor and an operational creditor also was challenged in that judgment. That also has been repelled. There are two very valid categories or class of creditors, financial and operational. So Supreme Court found no problem with that. Thirdly, and a very important legal principle has been enunciated in that judgment, is that in economic legislations, the courts should have a hands-off approach. Meaning thereby that whenever there are legislations or laws like the IBC, which have a direct commercial application, the legislature's wisdom should be given a higher priority, because they know exactly what is the commercial situation that is happening and what laws should be brought about, what regulations should be brought about, how should be tweaked, so that the maximum commercial benefit takes place, and the courts are at times ill-equipped to take a commercial call on various aspects, which is best left to the wisdom of the legislature. So of course, courts do have the power of judicial review in its full force, even over commercial legislations. But the idea is, or the well accepted long-standing norm is, that you have to be very, very conservative in exercising that jurisdiction, give the maximum possible leeway to the legislature to decide what economic policies and laws they want to bring about to achieve the required economic objectives. Then other issues, also some minor issues, for example, about the members of the NCLT, how were they appointed, which ministry is the controlling ministry. Because those all things also were discussed. Because see, another aspect of a tribunal, and why I call it salami slicing, is that the judge in the high courts, they are constitutional functionaries. They are not administratively under control of any department of the government of India. They are administratively, at best, they have to report to the Chief Justice of their respective high courts. And judicially, they are subordinate to, of course, intra-court appeals and to the Supreme Court. But administratively, they are a constitutional function, and as behoves the status of a constitutional functionary, they are not subordinate to another arm of the government. That is, they are not subordinate or answerable or responsible to the executive or to the legislature. Unfortunately, members of the tribunal come under the administrative control of one of the ministries of the government. For example, the National Company Law Tribunal, it is under the administrative control of the Ministry of Corporate Affairs. So a judge of the National Company Law Tribunal, for matters of, say, office appointment, retirement, service conditions, and even something as perfunctory as taking a leave, all that has to be routed, approved, and accepted by the Ministry of Corporate Affairs, the MCA. So this, to some extent, in my view, does impinge upon the not only the most celebrated principle of doctrine of separation of powers, but also the independence of judiciary, because you have to actually inure and ring fence or create a firewall of independence to even members of the tribunal. So these were some of the aspects. Of course, this is the last word has not yet been said on this. Supreme Court is still engaged with this issue in the Madras Bar Association case. I'm sure that must be one of the judgments that you all have to read. So in Madras Bar Association cases, although several judgments have come, but these issues are still pending before the Honorable Supreme Court as to how best to firewall or ring fence the members of the tribunal against any possible or hypothetical interference by the executive or by the ministries. So that's one part of Swiss ribbons. The next judgment, and the last judgment, is COC versus Satish Kumar Gupta. This is 2028 SCC page 53. 2028 SCC page 53, three-judge bench judgment, again authored by Justice Rohinton Nariman. And again, what all concepts that I've just told you all, that is the role of a resolution professional, who is a prospective resolution applicant, what is the COC, what is the SRA, all those things have been elaborately discussed in that judgment. One notable aspect in that judgment, which is para 73 of that judgment, if you would read at whenever you all go through it, is what is known as the power of judicial review and the commercial wisdom of the COC. Now, especially in the recent judgment, if you all have read the papers or read the case law in Bhushan, the idea of or some celebrated line of judgments, including Glass Trust versus Byju's, in Jet Airways case, and now in Bhushan Power and Steel, the decision taken by the COC to decide among whom of the PRAs, and if you all recollect a short while ago when I said PRAs are when the RP invites plans. Now see, this is the total debt of this company. Who is ready to submit its plan, give the best offer to the creditors, and take over this company. So all those people who apply are known as the prospective resolution applicant, the PRA. And among the PRA, the person which is, or the entity which is ultimately selected, is the SRA. Now, the process of selection of an SRA is not very simple. So it's not like a tender document that you open the tender bid and see whosoever is H1, you award the tender. No, there can be a situation, when the example that I gave, that somebody has bid 750 crores, but says that I will give you these 750 crores spread out over 5 years. And there is another PRA who has bid 100 crores less, say 650 crores, but he's saying I'm ready to give it to you in 6 months. The COC can decide that we will not go with this entity who is giving us 750, we will go with this entity who is giving us 650, because we are getting this cash upfront, and we don't want to wait for 5 years, we'd rather have our cash upfront. So that decision of the COC to decide which among the PRAs it would select as the SRA is known as the commercial wisdom of the COC. Why? Because it is their money that is stuck. Ultimately, the corporate debtor didn't pay them their money. So it is their money which is the subject matter of this entire dispute. So they know best how to recover their own monies, And the court should not be sitting as an appellate tribunal to decide as to which person they should go with and which person they should not go with, because ultimately it is their money which they have to recover in the manner that they deem best fit. So that is the concept of commercial wisdom, which Supreme Court has said, as and in para 73, it has upheld that principle, saying that the NCLT, NCLAT, and the Supreme Court should be extremely wary in interfering with the decision of the COC unless and until it is violative of specific sections of the IBC and specific regulations promulgated under the IBC. If there's a direct violation of that, only in that case can you interfere with the commercial wisdom. Otherwise, it's a hands-off approach. So a great deal of latitude, a great deal of leeway is given to the commercial decision, commercial wisdom of the Committee of Creditors, that is the COC. And then, of course, there are time limits for its completion. And then and lastly, we are running out of time. So I'll just conclude by this. Secured and unsecured creditors. That also is one of the important aspects here. Secured creditors has those creditors who have a security interest. Like, for example, a bank. When bank gives a loan to the corporate debtor, it would see that some asset of the corporate debtor or its promoters or its owners are mortgaged to it. They have a charge on that property. So they are secured by virtue of a charge that they have on some asset of the corporate debtor. So they become a secured creditor. And on the other hand, there are unsecured creditors, like, for example, a home buyer in a real estate project. The home buyer has given 1 crore of rupees to the builder for a flat. The flat has not come. So when that home buyer company, the real estate company, goes into CIRP, into corporate insolvency resolution process, that home buyer becomes an unsecured financial creditor because he has given money for which he has not received the flat nor received the money back. But there is no underlying security that he has. So he's paid the money, but he does not have a charge on the asset, on the flat. So therefore, he becomes what is known as an unsecured financial creditor. So these also, the interplay between secured and unsecured financial creditor also is quite complex. The last word on that also is not there because Supreme Court is yet to adjudicate that. There are two different views taken on the treatment of secured creditors by two different judgments of the Supreme Court, one in Amit Metallics and the other in Ruchi Soya. And that has now been placed before a larger bench, so it will decide. So this is an highly evolving area of law, and it is a bit complex because it's quite niche. It's quite heavily contested. So at the first flush, there would be certain concepts that might seem a bit overbearing. So that's the reason why I did not go into the specific paras and specific issues about these two judgments. My endeavor has been to probably try in this limited time that was available to us to give some conceptual clarity about various aspects of IBC, so that when you all read the judgment, these words do not seem alien words. Words like financial creditor, operational creditor, resolution professional, resolution applicant, COC, SRA, and so on and so forth. So once these concepts, these terms are clear, then I'm sure you all will have the wherewithal to go through the judgment and comprehend in a much better manner. We are quite close to the end of our time, and I thank you for your patience, and I earnestly and from the bottom of my heart wish you the best of luck and Godspeed and good luck. May you all give the examination, give it with confidence, and also, as I said right at the start, please approach this examination as a very important professional skill enhancement and not just an academic pursuit. Thank you, everybody.
Thank you, sir, for such an enlightening lecture. There are a few questions that I need to mention. Actually, there are a lot of questions that have been asked. Well, I'll just take up the relevant ones.
Yeah,
The
please.
first question has been asked is by Advocate Omran Khan.
Mhm.
That how do we approach a question while answering a series of judgment in one answer? Kindly enlighten us on the structure or ingredients to be mentioned in the answering the questions and some tips for writing the leading case exam.
See, I am an old horse. It's been 15 years since I gave the examination. So
Yeah.
I think somebody, if more than that, 17. So somebody who is cleared the exam recently would probably be in a much better position to give you these tips. But I can only share what I did at my point of time, that when there are a series of judgments, the best way to understand it it's a story.
Right.
You see, so it's don't take it as individual judgments. Don't put it in a silo. Treat it as a story. And again, probably I'm impinging upon someone else's lecture over here. Say the doctrine of basic structure. Now, if you just read about Keshwan and Bharti, it will be incomprehensible. And if you just read about so you read it as a story. For example, 1951, the first ever judgment of the Supreme Court in Shankari Prasad's case. Then
Hmm.
1964 in Sajjan Singh's case, then Golaknath 1967, and then Keshwanand Bharti 1973. So
Hmm.
in 1951, Shankari Prasad absolutely threw it out in favor of the parliament and against judicial review. The same thing continued in 64. But in Golaknath's case, Supreme Court did a massive change of law. It said that fundamental rights are absolutely unamendable. You see, and then in Keshwan and Bharti, ultimately a Y media was sought, saying that it did not take the extreme view of Golaknath, saying that no fundamental rights can be amended, but your amendment to fundamental rights is subject to what is known as the basic structure or basic features of our constitution. So if supposing there is a question on this, as to give your exposition or give your views on the various case laws pertaining to basic structure, you should know the story. So this is how you read the story. That on 1951's first time Shankari Prasad came, Supreme Court said, sorry, whatever Parliament says is supreme, they can do, their powers to amend the constitution is plenary and cannot be interfered with by the Supreme Court. So 51, 50s, was the position of law. 60s, it continued in Sajjan Singh. In 67, Golaknath, 11 judges, it changed. And then 73 came Keshwan and Bharti, which in turn, couple of other judgments like Minerva Mills 1980, Indira Gandhi and Menka Gandhi, they further clarified, and more judgments came about as to what constitutes our basic structures. You know what, for example, democracy, rule of law, parliamentary form of government, fundamental rights, and so on and so forth. So just to summarize, whenever you get a complex question which has multiple cases, you should understand the chronology of it. Go by chronological sequence to understand the underlying story, because we've been fortunate enough that now we have almost 75 years of Supreme Court's jurisprudence, and it has evolved in a certain manner.
Certainly.
Isn't it? So just get hold of that underlying story. If you get the background story, you'll be easily be able to understand the case law behind it.
Right. Thank you so much. The second question is by Mr. Prakash Jadhav, who's asked that whether relation between Sangeeta versus State of Haryana, Machi Singh versus State of Punjab, and Bachchan Singh versus State of Punjab, with connection to Union of India versus Shriharan and Mukesh versus State of Delhi.
No, for that, then you need to invite me for another session, because this is not something that I can
I
give a
know,
short
yeah.
answer.
Right.
See, as I said, these are micro issues within a judgment. So,
That's
so the idea is, what I would urge the viewers is, when you all come to such lectures, don't come having an idea of micro issues, because in an hour's time with 5 judgments, or in an hour and 15 minutes, you really can't do justice to
yeah.
micro issues. So just understand the broad concepts. And if there is any specific query, Mr. Jadhav, that you have on that, please let me know. Otherwise, see, even Machli Singh's judgment, etc. It has flown on the basis of death penalty. So the evolution of what death penalty has been, whether earlier there was no concept of a special category of cases. So all these cases that you have cited, the terminal point of these judgments would be Swami Shraddhanand versus State of Karnataka in 2008, where for the first time Supreme Court came up with this special category of cases, which I have adverted to earlier in my talk, that you need not give a death penalty, but at the same time, don't let out a person in 14 years. You give him a substantive sentence, a substantial sentence of 20, 25 years without remission, without him coming out. Yeah. Next question.
You're on mute, Meenakshi, you're on mute.
I'm so sorry. The third question has been asked by Nasir Khan, and he's asked that does the state have the authority to remit the life sentences of convicts without concurrence of the central government if the cases are investigated except the CBI?
So again, it depends on the laws under which they are convicted.
Yeah,
If there are central laws, then in that case, the state government's power is fettered by the opinion of the central government. It will always be subject to that. That is the underlying basis of Shriharan. Because you see, the state of Tamil Nadu in that case was very keen to remit the sentences of those accused persons. Central government wasn't keen. You see, so this is how the Supreme Court settled the law, saying that if the conviction is under those statutes, which are central statutes, then the consultation with the central government becomes a concurrence. So without their permission or without their positive approval, you cannot go ahead.
true. The last question is by Disha Wadekar. She's asked that whether there is any discussion on the separation of powers in Shriharan, and were these concerns reflected in the Justice Lalit's dissenting opinion, and also the relevance of the Gopal Godse case in V. Shriharan.
See, Disha Wadekar, Gopal Godse's case has been the starting point of the entire discussion of the case law in that judgment. Because in Gopal Godse's case, if I remember 1961 Supreme Court, that was a time when Supreme Court held this principle that if it's a death sentence, if it's a life sentence, it is a sentence for life. You see, so unlike, as I said, in popular culture, especially in movies where they said no life sentence and the villain comes out after 14 years. And in some cases, he comes out even before 14 years because astonishingly, he was a bad character outside, but inside the jail, he was at the best of behavior. And then he got a few years of revision. So, and then, that leads to great deal of consternation that how can, a life sentence guy come out in just 10 years flat. So therefore, in Godse's case from 1961 onwards, Supreme Court has consistently held that when it's a life sentence, you cannot put any temporal restriction on that. You can't say life sentence runs for 14 years or 16 years or 18 years. Life sentence means life. That's been, but then of course it was always subject to the powers of remission and the various jail manuals and of course the ultimate power, the power of pardon.
So the last question is by SCAORA EC. Will you be able to share your notes with us for your aspirant?
I'll send a scanned copy to Asta.
Thank you. Thank you, sir.
But you would need exceptional skill to comprehend my handwriting, I must tell you.
Oh, no, I'm sure the aspirants will be able to do
So
that.
they have an expert amongst themselves to read your handwriting, so I will help them out with that. So no problem at all.
No, it's just a few scribbling of notes. I didn't actually make any detail this thing. I preferred to go through the judgment. And what I realized is that even the time space constraints that we have, instead of going too deep into any specific judgment, because these cases are huge constitutional judgments, and every case would probably take an hour and a half if you have to actually go threadbare. So instead of giving a worm's eye view, I thought it is best to give a bird's eye view. And that's the reason why we could complete it in an hour and a half flat. And secondly, as I said right from the start, the idea is to just clear a few concepts here and there so that, and most of you all are accomplished lawyers yourself. If you are giving the AOR exam, please understand you all are a very, very exclusive lot. Among the lakhs of lawyers in the country, very, very few hundreds or few thousands probably have the chance to give this examination. So always consider yourself very fortunate. Think about all those lawyers who do not practice in Delhi, who practice in all over the country and who look very enviously at Supreme Court and Supreme Court based lawyers, hoping that they get a chance to practice here. So I think among the 25 lakh lawyers all over the country, it's only a few thousands of us who get to practice in the Supreme Court. And we should be very, very fortunate about this chance that life has given us. So best of luck and go ahead and crack the exam and be fearless.
So I'll just conclude with the vote of thanks. And I, on behalf of the Supreme Court Advocate on Record Association Executive Committee, I extend our heartfelt gratitude to you, sir, for being an esteemed part of the SCAORA AOR Lectures 2025. Your illuminating insights on all the judgments and related important judgments have been invaluable. And your expertise in highlighting the important paras and crucial topics for the exam will undoubtedly benefit the AOR aspirants. Notably, sir, as told to me by Asta, that all your juniors have already cleared the AOR examination, and which is 13 in number. I'm sure all the aspirants here who watch this lecture will gain from your in-depth knowledge and providing aspirants with a first-hand understanding to what it takes to excel. So your thoughtful analysis has provided clarity on important questions, giving aspirants a significant edge. We appreciate your gracious presence, sir, and we look forward to have you again for the AOR lecture series. Thank you all for everybody who's watched this lecture in large numbers. I, on behalf of SCAORA, wish everyone the very best of luck for the upcoming AOR exam.
Thank you. Thank you.
Thank you, sir.
Thank you.